Hi, good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. They're really excited to have, and I think she's very excited as well to join us again. And thank you so much, Stephanie, for joining us. Maybe you can tell us a little bit more about yourself, about your practice, and all the other things you're doing, and then we can get started from there.
Awesome. Thank you for having me back. Yes, I'm way too excited because I started talking before this was even recording. So here we are. I have been practicing as a paralegal in Ontario for 10 years this year, and I have my own practice called Bent Law Legal Services. I am a multidisciplinary firm, and I do everything from criminal to a lot of tribunals, small claims, kind of just a Jill of all trades is what I'm going to go with. So I've been doing that. I have a lot of community involvement. I'm also a member on the OPP, Friends of the OPP Board Association. So I do a lot of community involvement to kind of bring the legal world back into the community, which is how I was taught originally, is to always give back. So I'm in a bunch of boards for that, and a member of Arch Disability that worked on some very important things during the pandemic to help with disability rights to the tribunals and whatnot. So I'm very busy, and then I decided to start teaching. So I'm also a part-time professor at Georgian College, which I'm very excited about, and it's a new adventure, and I don't believe in sleeping. So that's where we are at.
So yeah, let's start with the teaching there. I mean, how was the I think it was the first semester here, and I know there's certainly in the summer semester about to start in a couple of weeks. It's going to be back in person. So what did you find from your first experience, and how was sort of the virtual thing, and what were the classes that you were teaching, and what do you have on tap in the summer?
So I'm teaching admin law, and they are having their exam on Thursday. So I know some of them are going to watch. So good luck. I know you're going to do awesome. So I started out with admin law, and next semester I'm small claims, employment law, immigration and refugee board, and WSIB and accident benefits. So that will be fun. Now, virtual versus in person, I can't comment on the in person yet because I only know that from being in court, but I can understand the challenges of learning online now because I went to school in person, obviously, a million years ago. And I don't know what any of my students look like. They're little gray boxes, and none of them had pictures. So I'm going to be as shocked to meet them next semester as they probably will be with me. It was weird, but we went through PowerPoints. I think that it takes away a little bit of the legal world is interacting with people. And I remember in school, we had the groups to work with. So you kind of got used to colleagues and working with other people, whereas you're very segregated in the whole virtual world. And then it led to, issues of plagiarism. Can you tell? Because people are shifting things and you don't know who wrote it because you don't know who's behind the box. So we didn't have a lot of that, just to be clear, but at the end of the day, it's just very weird because I don't know what any of them look like. I have no clue, not a single soul. So when I go into class on May 9th, I'm going to be as surprised as they will be to see them. And I'm kind of excited about it because I think that being in person and be able to work in a group and be able to work through things together, especially had a lot of international students that don't have anybody here that are now in Canada. They're going to be able to make friends and form those connections that will be important when they're in their career. So I'm kind of excited about that, but the virtual learning is insane. I bless their soul that everyone's made it through doing this through the pandemic, and hopefully we can stay in person. I know it's still going to be a little bit different with masks and whatnot, but I think it'll be easier and a little more feeling like you're doing something and being able to attend courts in some capacities. I mean, that's still pretty limited, but at least they can go physically on a field trip to see what one looks like versus Googling it. So there's just so many things that I don't even know how easy it would be to go to court after. I mean, as long as we stay on Zoom, they already got this down pat. But to go in person, it's going to be a very different monster. So it was educational. Let's put it that way. I felt educated after finishing it.
Yeah, I mean, and I think certainly getting to the end of the semester for your students that are in administrative law, and that there's so much you can learn, and it's again a great example to go and actually see the Immigration and Refugee Board, or to go and see the Human Rights Tribunal of Ontario, or wherever where you would have been able to do in person there before. Now you had also mentioned there in Perfect on Tribunal talk there that with respect to your work there with disability law and some of that, maybe you can highlight some of the things that came up and where that's even bigger of an issue, right, is for people who have disabilities and try to cope in this Zoom era for the last couple of years, and what was the progress and result of some of those cases?
I would like to be really positive and say there's been a lot of progress, but there hasn't. And unfortunately, the gravity of the pandemic, there was a lot of things that came out that made the issues and struggles that much worse. When we discussed the triage protocol that was coming into place, that thankfully we never had to use, disabled people were last on the list to get care if it came down to that. And when it was brought to human rights, they said that it wasn't technically a discriminating piece, but how is it not? Because you're being judged based on your health, on your disability, on your age. It was a whole slew of things, and it was a nightmare to have to go through those different appeals that this organization, Arch Disability, which is great, has a bunch of lawyers, volunteers, paralegals, anyone that wants to volunteer, social workers, that really fights for different things. The only thing that came out of a lot of that time frame, I mean, they're pushing and they did have minor victories, which is controversial, was the dying with dignity was a big thing that came out in the pandemic, but no one heard about it because everything else was going on. So recently some controversial things have come out with that too, but that's now gone back to human rights to discuss. So it's been a mess. ODSP, if you needed to qualify for it, the Social Benefits Tribunal did not have any adjudicators because they retired, and they had to reallocate from the other tribunals, which there's tons of tribunals, and people were getting sick and it was just very short-staffed. There hasn't been a lot of room. Human rights hasn't been moving as fast as I would have loved it to, if at all. So there has been so many issues, especially with disability, is that people are feeling very, very left alone. And we have to advocate even to smaller areas, like going to the city to try and get things pushed, going to your local MP and pushing. So it's a little different avenue than it was pre-pandemic, where we would just go to, the Social Benefits Tribunal, or go to child reform tribunal that would deal with CAS and whatnot. You can't really do that right now because it's such limitations and backlogs. So you really were looking at all those other channels like the Ombudsman's office and MPs to help you, which was new to us. That was not something we had to do. It was a formal process, but we had to look outside the box. But it is still a work in beautiful progress. I want to be hopeful that we start moving forward. I know there's been a push because there's an election, and usually people really like to get some help during an election because everybody wants to look great. So we're hoping that moves, but it's been limited and very hard. But the tribunal hasn't even really done Zoom things because of the disability restraints. Some people are in Northern Ontario or remote locations that they can't do it. They also can't go to any physical locations because they hadn't scheduled any. So we are now left again in a situation of it being kind of prejudicial and not moving forward. So it's been a mess, and it's unfortunate, but the nature of the times has just been hard to fix. I know they're on it, and things are starting to be scheduled in, I think, court locations, but it's a work in progress. Wish that was a more positive answer, but it's not. So
and I guess maybe to extrapolate on that with respect to, I know you mentioned a number of different specific tribunals and certainly teaching administrative law. What in terms, and we were just talking about the Zoom era as well, but what can you find in terms of, for students who are listening, or recent calls and young practitioners adapting to this kind of hybrid now? I mean, before it was like everything was going virtual, but now we're kind of coming back out of it. And then you have the opposite effect that students who had studied remotely maybe did their internship remotely, and now they have to go appear in person. And it's kind of like a new era. What can you share from your experiences, as an advocate, both in a Zoom world and in an in-person world that you touched on And is it the same thing, with let's say advocacy before a tribunal, or is it completely different, or what have you learned, or what can you share with us?
I would say it's probably completely different. I mean, I was just informed today that I have to go to criminal court in person in 2 weeks. And I was kind of like, oh, I haven't been to an actual physical court for 2 years. And that's different. You have different decorum, different ways. I mean, people are used to not getting dressed from the waist down. They're just wearing their pajamas and they're dressed like a professional up top. So that's a major difference. You have to dress professionally, completely as a suit and not pajama pants. So there's that. And then the decorum of a courtroom. Now, if you've never been in one, you notice on Zoom, even with the small things of, I have no further matters, may I be dismissed, asking a justice or a judge whether you may leave, they don't have that on Zoom because it wasn't the formalities of the courtroom are not happening on Zoom. So what's a good example? I had the Law Society Tribunal, so I'm going to use them because it was an interesting ride on there. They still have the decorum of a typical room. You are to explain your last name and spell it with initial, for me, Bent, B-E-N-T, initial S. And you're the paralegal here for your party. So that's the decorum that you had before pandemic. And you'd walk in and you'd bow and when you're passing the bar. And when you're leaving, you always ask for that permission to be dismissed and you bow again because it's just respect that you were taught. Doesn't exist in a virtual world. They come in and they have they're not, I shouldn't jeopardize, I'm not going to say everybody, but a large quantity of people on both sides of the spectrum, paralegal, lawyer, and agents that show, do not have that. They just kind of feel out of place because you're at home, you're in your environment. Not everyone works from home. And you don't have that decorum. Some are even forgetting to address them as your worship or your honor. And I think that's because of the lack of being able to be in place. So a mentor is a wonderful thing to have, especially from the old birds like us that are able to remember back in the day when we went to court and not through a computer, that it would be helpful to say, when you go, just remember these things, have prepare yourself for when you're in court, because that's the best thing to get through. If, everyone likes expediency, no matter whether it's tribunals or courts. Different world. You're sitting in the comfort of here, like my home office. I'm happy to be here, but I have all my paperwork around me. It'll be the same in a courtroom. It's just I'm not staring with a ring light and Zoom staring at me, but I still have to have that decorum. So I do think that the proper decorum and practices are absent. And unfortunately, when the mock trials used to be in a court, and that taught you the decorum, and now it's online with cameras off and we don't even know what a trial's like right now online because they haven't done them. So for us, I think it's easier to go back. For them, I think it's going to be a challenge because you may get called out on the fact that you don't know those simplistic decorum that does mean a lot and shows your professionalism. And it seems like such a trivial thing, but it's not. So I think that will be it. I don't think that the arguing and the advocating will be any different, but it's also waiting and not having to press a little emoji that raises your hand. You have to actually wait your turn and not be like, excuse me, may I go? And I think, again, that's going to be difficult. So a mentor is a great thing. I have had a couple of myself come with me. When I physically took them to the court, we didn't have a court date. I just took them there. Said, let's go to the court. You just walk inside and see what it's like. And then I asked one of the bailiffs if I could just go into a courtroom so they could see how it's set up. So they'd never been in a courtroom. That's terrifying. So now that we're going back, it'd be like your first day all over again, walking in and being like, what's this? So, for some things, it will always stay here as far as I understand, but for other things, it will return to that world. And it is going to be a little bit scary in a transition that they're going to need help with, I think. We're probably going to need help with it going back, to be perfectly honest. There's humans in less than 6 feet from you. You have to figure out how to do that again. So it'll be something.
And I'm glad you also touched on the mentorship and the coach. And I know you're involved with that as well. And maybe you can tell a little bit more about the importance of mentorship and whether it's the decorum or understanding a new tribunal, right? Maybe you've never appeared before the Law Society tribunal before, and you happen to get, you're doing disciplinary matters, and maybe you had, another organization like maybe the Ontario College of Teachers, and now you're doing a Law Society tribunal, and it's getting that guidance, especially, I think for paralegals, a lot more are sole practitioners, that it's hard to kind of have a network of people where you can go down to like a big law firm and knock on 4 different doors, and back when you could do that and everyone wasn't at home either.
Yes.
So maybe you could tell us a bit about how you got involved with that, and the benefits of that, and just mentorship generally.
Sure. I started out simply just doing field placements that different colleges throughout Ontario, especially with the remote. I had a lot of stuff. I was very fortunate during the pandemic to still be busy because of the nature of my business. And I hosted a lot of students, and I'm thankful for that. They taught me a lot. I hope I taught them a lot. It's a good thing, because especially during the pandemic, I'm going to say with people that solely did POA, for example, there's a lot of licensees that have been around for a long time that's all they did. And with that court being shut down for 2 years, they needed to learn something new. And instead of just flying by their coattails, they went to another person that was experienced and was able to help them, and even online. So myself and one of the benchers just have a paralegal mentor mentee group on Facebook that is a safe place, that if you have a question, there's no question that's silly, no question that's going to be berated. You want to ask something, then ask. And there's a group of paralegals that have been here from 25 years to 2 years, and they can do their various ranges of what they've experienced. And that's a great thing, because it's a roadmap to get you there. Now, for mentoring in general, for a few that still are with me, they get to go into different areas of the law that they didn't really think they could go into. And that with the tribunals, I know we were talking earlier, they don't really know how much we can do in that section, and how amazing of a practice you can have being like buried in that area. So you can have exposure to things, see how someone does it. Maybe, for me, I like to I give it to them and say, you tell me what you would do with it. And then I'll go through it and say, here's what I would change. Then we talk about whether it could still work, and kind of find a way to guide you down a path that you are learning the proper procedures. And for me, as I tell my students, and I tell anybody that I know, the legislation is always the important part to go to, because each tribunal has their own legislation that dictates how it operates, whether there's orders, whether there's a tribunal. If it's just mediation, like consumer protection, they just do an investigation, but it doesn't get enforced. Ministry of Labor does. And you go to the Ontario Labor Relations Board, they have a tribunal in between that can decide and mediate things. But all these things are small factors that are in that legislation. So I always push the legislation. I think that a lot of mentors do that have been around for a little bit, but it's a good teaching tool from someone that's done it. It's like when you work at a restaurant, you'll shadow the bartender or shadow the waitress, because you're learning what they did. And sometimes it's not a good thing that you're learning. You're learning the do's and the don'ts. Sometimes you're going to learn from a mentor and be like, I'm not going to do that. But it's a balancing act. And for this career path, it's great to have someone that, if you have an issue and you're like, something doesn't really sound quite right to me, can you help me out and see like which way I would go? And that's how I got into the CAN coach with the Law Society, was because it's a great thing to help with practice management. There's so many things, especially at tribunals, and being one of the few people that does it, giving a little clarity of what the hearing process is and what someone can expect. So I think it's a guideline and a great pinpoint to have a person for information and a person that can show you it. And like you said, the decorum, when we go back into a courtroom, that's a big deal. Even a student that was with me at criminal last week, he asked why I asked to be released. I had no more matters. May I leave the court? And he's like, he could have just clicked the box. And I said, well, that's true, but it's not proper. Like if I left, then I wouldn't be doing my professional courtesy to everyone around me and thank everybody for the time and the justice and your friend that is the Crown. And then you just ask if you may be released, and it's that's just decorum. And that was online. So that shows you there's a little bit of a gap of understanding those things. So I think having someone to follow, he learned something that day and now he's going to go forward. And when he's up in front of the wolves that he will be thrown in front of one day, he will know what to do. So I think that it's beneficial. And I think even people that have been doing this forever should have a mentor they can talk to. I do. I'm very fortunate to have a couple, and I'm thankful they guide me in the right direction. Thankfully, I still am here, so that's good. And hopefully I can do that with more people as well.
Now, since you're teaching admin law as well as we talked about tribunals, and I think you brought up the really good point there is a lot of people don't understand that there's so many tribunals to begin with. I mean, I don't know if there's someone has a running list, but I think I had a paralegal on before, and she had mentioned maybe 1,000 that you could appear before across the, and maybe you can share kind of about how there's that misconception, right? That people think, hey, paralegals, you can only do POA or small claims court, and that's pretty much it. And even in criminal law, right? I mean, people don't realize that there's a whole slew of summary conviction matters, right? Especially after 2019 and the changes, right? That there's a lot more at stake that people don't realize, and they think, hey, we're only limited. But I mean, with tribunals, you essentially have the full scope there, as a lawyer does, and people don't realize. I mean, especially I talk with the treasurer, and then we look at the numbers, and I'm like, well, why aren't more people doing human rights tribunal work or WSIB work? And so maybe you can tell us a little bit more about sort of those areas that you practice in.
Again, so in Ontario alone, there are 13 adjudicative tribunals, and that seems like there should be more, and there are, but they're made up of agencies, boards, and commissions. So you've got your tribunals, which are 13 main ones for Ontario, and then thousands of boards and commissions, like the Alcohol and Gaming Commission, the Liquor Control Board, which no one thinks is an actual place that things go on, but it does because of different things with alcohol laws that goes with the Alcohol and Gaming Commission. It's just like a slew of things that people don't understand are connected to each other. And it's a world that, one, requires a lot of focus, and it is a lot of work. And I often wonder if that's why no one wants to do it, because it requires a lot of time. So the anchor ones are always small claims, criminal, landlord and tenant, POA, because they're the generators. But these ones are long-winded. I mean, human rights can take anywhere up to 5 years for a case. So, but it's an amazing thing because you've done something amazing for a person. So I think that it's also the training, and I'm trying to work with, I know Law Society has pretty stringent things for the colleges as far as that goes, but human rights and WSIB are kind of just things in passing that you learn when you're in the program, and you don't really learn enough about it to, I would say, confidently walk out of school and walk into a tribunal, because they are their own monster. And I think that they think that everything fits into a box that's similar, but they're so different from each other. So when I say that, WSIB, for example, workman's compensation, the big scary one that nobody wants to touch because it's messy and it's long and there's so much to do, but it can be achieved without ever going to the WSIAT or Workplace Safety Insurance Agency Tribunal, just in case I realize that the acronyms kind of get ahead of you. You don't have to step foot in there. You actually use your ADR, which is the most amazing thing that you learn to resolve that issue. But if you can't, once you've got to a progression in a case, that tribunal is there for somebody to make a third-party view, which is great because these are people that were injured. There's some people that are paraplegic after workplace injuries. There's some really sad stories. There's some simple stories where it's just, they hurt their arm or they have carpal tunnel. But you learn like an American medical guide that teaches you so much. And you learn so much from these tribunals, more than you ever think you would. And you really have this heart for it. Go to human rights. There's up to, I think, 13 grounds now that have been added. You're going through fighting for someone's rights not to be discriminated. And these cases are not soft cases. They're emotional, they're intense. They're the ones that you're fighting for and you feel good about. And I think that's the difference with the tribunals. I'm not saying you don't feel good in small claims and landlord and tenant, but this is just a different world where you're really making a difference. But then on the other spectrum, there's like the Consumer Protection Board, where you may have not felt that your service was great with somebody. You don't quite want to go to court. It is technically an agency instead of a tribunal. You go through mediation processes. They make a decision. That's it. Doesn't go anywhere, doesn't get enforced. You take that decision and go to small claims. Some people would argue they feel like they wasted their time, but they didn't really, because you're going through to mediate and show that you tried. So it's like night and day. Ontario Independent Police Review Director. I do a lot of stuff there, which not a lot of people even know what to do with that. And that's dealing with the behaviors of a police force. And that could come from profiling, or it could just be a bad interaction that you've had that was unprofessional, you don't feel good about. That goes through to the police, then it goes to a tribunal. And if you don't agree with it, you go to the divisional court. No one knows this process. So I always like, and I shouldn't say always, I've taught it for one semester, but I tell them that there's a slew of things that can come from administrative law. It's not just the basis of law and the charter and all those kind of things, but it's showing that there's all these agencies, commissions, and tribunals that make up so much that's not just like an episode of Suits and running to the court to yell and fight and argue so like out loud and yell and be that courtroom drama. It's actually going through these specialized things that have been set to make it easier on your client. So it's not necessarily about you wanting to be that advocate, it's about the client. And that's really what the tribunals are great for, is it's about the person. It's not about the fight. So that's a big deal on its own.
Now on that, with, I'm glad you brought up the ADR, right? Because a lot of people think advocacy, as you mentioned, is just oral advocacy and specifically in the tribunal or the courtroom. But I mean, what about the importance of, whether it's at a WSIB matter or wherever, where you can reach a resolution before, and how the importance of advocating with for your client with the other party, and you could avoid the tribunal hearing itself, and how that's important. And as well, I mean, you mentioned a bunch of different tribunals. Now, you can't just walk into the landlord and tenant board and expect it to be like WYSIAT, right? I mean, the procedures are different, and the importance of kind of understanding that in terms of advocating. So maybe you can share with us a little bit more about ADR and advocacy before the hearing.
The ADR is probably, I think, and I will stand behind this forever, the single-handedly most important course next to advocacy that we get. Because, for example, any tribunal, a lot of them are based on, again, that emotional, really hard things that have happened to somebody. It may be exciting to go to court and go argue and have the whole experience, but you also have a client that's been put through a lot of stuff in their issues, and even to criminal court, there's CPTs, Crown pretrials and judicial pretrials that are done to try and avoid going to trial, because you're taking the stress off your client. And that really is the whole point of our existence, is to try and help somebody and take that strain off them and help solve that problem. And tribunals, that's especially true. When you go to human rights, for example, you'll file your application and it'll ask if you want to mediate. Most people say no because they're angry and they've sent it in and I'm not going to mediate this, I'm done. Then you get to a point where HRTO says, here's a mediation opportunity. They don't care that we didn't check the box. They're giving it to you again. You can say no, you can pass it. So you get scheduled to a hearing. Once you walk in the hearing, the first hour is mediation. So no matter what you want, you're going to mediate this. And if you can't figure it out, then that's fine. So the ADR is there in everything that we do. And it's trying to resolve that issue without added stress to the person. WSIB, I have about 20 cases right now. Not one of them has ever gone to the tribunal. I have sat with case managers. I'm rarely, I read the American Medical Association's guide far too much. So I have the policies and I have that and I refer to that. If you go in knowledgeable and you go in with the proper things to apply to what's going on situationally, you will do far more than going in and arguing and getting a final answer. Instead, you can sit and work with somebody. And if it doesn't work, that the case manager, which in rare occasions, although most people would argue it's all the time, in rare occasions, The caseworker may not want to work with you. There's another commission that's a tribunal called the Fair Practice Commission that governs WSIB and makes them have to do what's just and right to natural law. So you've now mediated it. You've avoided pushing your client through this, which is a stressful thing for them, just as it's stressful for us to prepare. It's more stressful for them to go through that. And we're kind of preventing it. So that ADR, no matter what you do, in my opinion anyway, whatever part of law you are participating in, and even in your life, realistically, mediating out of things to get rid of conflict is a better way to go, especially we've been living in kind of a sad time for a couple years and people are angry, and we need to get back to being able to socialize with each other, and that's a good way to do it. And I know we have clients that call that are angry because certain things aren't moving, but we have to try and mitigate that and explain. And if we don't have those skills, then we end up not in a great place. So I think that it's extremely important. The tribunals, I can tell you, it is 110% important, because they don't want to go to a full hearing. That's not the goal of them. The goal is to stop that. But sometimes it happens because the parties are just too far apart, but it is a valuable tool, I think.
And we were talking about advocacy in the sense of at a hearing, and now here at mediation. Differences, we were talking about Zoom versus in person, but I mean, how do you prepare for, let's say, a mediation differently than you're preparing for a hearing? And I think sometimes, especially when we have the ADR class that I teach, and there's like a mock mediation, and students are ready to go to trial, like in the mediation, and they think that this is just an informal trial. But what can you share kind of about getting the best for your client through the mediation process? As you mentioned, there's these 20 files you had, and none of them end up at the tribunal itself. But I mean, it's not just like, just take the first thing and run with it, right? I mean, how do you kind of get a good result for your client without essentially just avoiding the tribunal just because you have no other choice?
And I promise that I'm not referring to every class that is part of the paralegal program, but honestly, this goes back to legal research. So before a mediation, I'm going to use human rights as an example, and then maybe WSIB. If, let's say, it was discrimination in employment based on disability, I am going to look up the disability, and I get a lot of first responders with PTSD, which is very serious and unfortunately very common these days. When I'm going to go in, I will look for case law. Canley is my best friend. I love Canley. And we look up to see if there are any other cases that PTSD was brought before the Human Rights Tribunal, and how did that go? Are there any factors that look like my case, which you should have case law anyways when you're getting ready for a hearing. So you already have this because you've done all your due diligence. So you're just using it to help you prepare for this. And you're going to look at that. Then you have to have sometimes a hard conversation with your client, because sometimes they don't want to do this. They have no interest, and they are going to be pushy and say, I don't want to do this. But you have to find a way to say, here's what this situation did. Here's the parallels with yours. Here's some gray areas. I always like to do like a chess match when I'm doing stuff or prepping. I always think about my side, but I always think about their side. Because if I don't think about their side, then I'm being very ignorant to the fact that there is another side, and I am not the only person here fighting. So I'll prepare what I think that they could come in with, what I think the little weak links are, and then I'll explain what I think the process would be. Then I ask them what their reasonable thought. For example, human rights has a monetary limit. So I'll ask what you would think was reasonable. It's always super high, always. And then we have to become more realistic and look at what the facts are. And sometimes maybe it should be that high. Maybe that's correct. Maybe they're too low in comparison to what's there. But there's a lot of that. Then there's the stuff that's non-monetary. Should that company receive human rights training? Should they have follow-ups and investigation over the years? Is that included in these cases? Does their legislation provide for that? Go back to the Human Rights Code. Look there and see, how strong is this? Some people will have a very strong case and say, nope, I want to go through. And sometimes people just want it to go through because they want it to be uncannily, because it's slightly, when it's out there in the public, someone can search it and they're going to see this company did this. win or lose, they're going to see that they were brought there. So it's managing your client in that way, and then also having the correct information. Now, WSIB is a different monster. The problem with these is they are very long cases. I have one that's from 2016. It's just getting settled now. That's a long time. That case required endless nights of reading medical journals, of understanding the policies for WSIB and applying them. And again, it's going back to legal research, going to past decisions for WSIAT and seeing where did this go if they had it. And then also knowing the case manager. You've been with that case manager in that event. There's been like 18 of them because it's so old. It's just kind of people have left their job and come in. And you know how that person's going to be. And you really try to put that forth to say, okay, this person's not going to be able to go back to work because this is a debilitating permanent impairment. This is what they're losing for their salary. This is what, the AMA guide says about percentage of disability, and this is what it should be. And you put that through an appeal. So that's all in writing. You don't ever speak to a human, and then it's done. Whereas in human rights, you're before somebody. So I think the preparation is the most important part, but I think that's with anything. I think you should always be prepared and not coming in just to, go naturally, because that never works out. And you're going to be asked questions that you don't have the answers to. And with those tribunals, because of how specific they are, you should know them left, right, and center and what their legislation is. Because if you don't, when they call upon you to say, why do you think your opinion is strong for this, and you have never read the legislation, not going to take you seriously, and they don't. So, self-represented parties in tribunals, I hate to report, are not treated the greatest. They're supposed to be easier for them, but they are kind of thrown off because they think there's no legal party to give them representation. So that's also something. Did that person go into this unrepresented and now we're at mediation with representation? Things might look very different. And I hate to admit that that's the case, but it does happen. So you just have to read how the case has gone and be very knowledgeable, because you should never have a question where you're like, I don't know.
And so, certainly preparation, regardless of the tribunal or court is going to be vital. And you also touched there on sometimes, a tribunal or a board or a commission or an agency, right? It's written submissions, right? And as much as, again, we were talking about, the glory of suits and Harvey and being in the courtroom or being in the tribunal hearing your written advocacy, or even just in preparing the application, right? Sometimes you may have like a boilerplate or someone says, here, take this one and fix it up. But you're also missing that opportunity with either written submissions or a written hearing, or even just an application that that's your first chance to put something before that tribunal, or maybe your only chance, right? There may not be a hearing, and sometimes the written advocacy doesn't get the glory. It's kind of like in sports, the defense doesn't get the glory as the offense there, but just as important. Maybe you can tell us a little bit more about your written advocacy, right? And what tips maybe you can have for students about writing, because you mentioned legal research and writing, and I'm also glad because I'm also teaching that class with students earlier, and everything's interconnected.
Good. You know what? And I think that is also something that lacks, and it lacked for me when I started. I'm not going to lie to you. I remember my dad's a paralegal and he's an ex-cop. He looked at my Schedule A's and was like, nope. And I went to a great school and I had gone through all my education and it looked like a mess. And I learned, but again, that goes back to mentoring and having someone help you go through your documents. I prefer written. I am obviously someone who enjoys speaking. However, I prefer the writing, because I have always been, before I was in law, I worked in fashion, which sounds like Legally Blonde reversed, without the blonde hair, I guess. And I wrote a lot of articles on different things, which sounds silly, like fashionable things, and it had impact. And then I changed over to this advocacy. I started advocating for disabled people before I even got into law and went to school for it. You can have so much impact on what you write. And that's why social media is scary, is that sometimes what you put out there can really get somebody circulating it. And I think we saw that in the last 2 years, is that there's a lot of misinformation. So we have to be careful with those kind of things with writing. And a lot of legal people are now doing blogs, including myself. And you have to watch what you're writing because it can be impactful and it can be emotional. Now, for me with the tribunals, WSIB, I am fighting for that like it's my own injury. I am writing every aspect in a beautiful pleading that took me a long time. So don't feel like if you don't get it off right at the first, it's okay. It took me 10 years to perfect that. And I'm sure there's stuff about it that could still change, but it's making it clean and readable. And that's what they need. But I am advocating as if I was the one that got hurt on the workplace, or it was me that was discriminated against. And I fight very vehemently through words. And I'm making sure that I'm quoting the correct things. Again, back to legal research, I'm quoting those things. If there's evidence that's necessary, depending on the legislation of the tribunal that has evidentiary rules, you have to be careful with what you're putting into submissions. Recently, I had to do a summary hearing written submission for the Human Rights Tribunal. Never had to do it before, but we're in a new world and it was something new. It was 75 pages at the end. God help anyone who has to read that, but it was impactful. It had all the proper information. It did not have the extras. You have to make sure you're clear, concise, and correct, and that you're not putting in the flowery stuff just to make it sound better. You're just sticking to facts. It's black and white. Here's the issue. Here's the problem, and go through it. So I find they're very lengthy because when you're speaking in person, you do tend to argue faster. But now you have to put this in a pleading. So making sure that that is well written is a big deal. And that's even for anything. If you're writing a letter to another licensee, you want it to sound proper and like you know what you're doing. And that's kind of a lost art these days, but we're trying. And then with emails, people are so used to sending emails, they forget to say like, good afternoon, good morning. And it's just simple things, but that goes back to that loss of decorum. But the pleadings and whatnot just have to be very, very clear. And if they're not, they will send it back to you and be like, I don't know what you're talking about. The Federal Human Rights Commission, if they don't like how clear you were, they're just like, nope, write it again, send it back. It feels like you're in school again, actually, because they just don't like it. They'll send it back. And you're just like, oh, okay, well, got a bad grade on this, got to send it back. So you do learn as you go, but at the same time, you don't want to be in a position to be learning as you go. You want to show your best foot forward. So writing is important. You should listen to your teachers as they teach you about all the writing styles and how important it is, and drafting. Because I know that in small claims, I'm going to have a lot of drafting exercises with my students. And bless their heart, after all of the criticism I've had over the years, I'm just going to provide it for them so they can jump faster than I did anyway.
Perfect. So Stephanie, thank you so much for taking the time here, joining us and sharing about all your insight there. And it's great that, you're certainly taking, I'm sure you're, as you mentioned, a lack of sleep there, but great that you'll have a bunch of classes there to teach the next generation coming up into getting into the practice there, in particular, those areas. So maybe if any final words of wisdom, we probably did this about a year or so ago the last time. So I don't know if now, from this experience of teaching has provided you with some more insight from students. They may be listening to this and they have an exam in a day or two, right? As well as your new students might want to hear more about you. What can you share in terms of, getting through school, getting into the profession? Certainly a unique background there that you just touched on at the end, right? That often people think, hey, what does this have to do with practicing law? And there's so much, right, in terms of writing and customer service and all these other skills that they don't realize is just as important in the legal profession. But any final words of wisdom? And thanks so much for joining us today.
Sure. I will say this, and I've had colleagues kind of say that they never understood it. I bartended to pay for law school and for school, and you learn a lot of skills of communication there. So no matter what you did before you come here, you could have been a dishwasher at a restaurant, you could have worked at Walmart as a greeter or just as customer service. All of that at one point in your career is going to come out as something beneficial, because you're going to think, wow, I was in this position at one point. Now apply this to what you're doing now. it doesn't matter what you did before, it's where you are now. But it really is, everything that you've done will come together in this career. And I can't tell you how many times with fashion or even bartending, which sounds like something would never come out of that, it did, because I was speaking to people all the time. I was confident with speaking with them. So it gave me a little more confidence. I'm not going to lie to you. I was terrified to go in front of a judge. I was horrified. But then eventually you learn to not do that. But I've also heard from students and new licensees that this is kind of overwhelming and scary right now, because it is a new kind of thing that everyone's coming into. Some of us have been really tired. We've gone through a lot and may not be as receptive and kind as some should be. And some have decided they just maybe don't want to continue on with the education. They don't want to become a paralegal. Don't give up because of one person. No matter what you do in any career, there's going to be one person that's going to be the bad apple and the sour puss that's going to say something to you, and it's not going to be kind. But that doesn't mean you can't change that. Like, we are really hoping and we believe in the future of the new students coming in and the new licensees, that you're going to be a legacy for all of us when we decide to retire. So, that would be good. And you're going to move up and you're going to move and shake what a paralegal does, because I mean, this is something that has grown in Ontario and hopefully across Canada at some point, which there is, as we were discussing before, there's little rumblings of that happening in certain provinces. But Ontario is very fortunate to have this, and you're going to be part of that. So don't let a couple negative Nancy's say something to you that makes you feel like you can't do this. And your classes, as stressful and at times, I hate to say this, boring. I know they're boring sometimes. We try our best, okay? We try our best to make them not boring, but they are going to be part of your life. It's not like when you were in high school and you're taking some weird math course that doesn't seem like it's going to apply in your life. It does at some point. You just don't know when. So don't give up. Keep positive. I mean, we've all been through our ups and downs, and you'll do great. You have such wonderful professors, such as, John and everyone else that I know that's teaching. And I'm not going to put myself there because I've only got through one semester so far. So if I make it to two, I'll maybe put myself in that category. But you just have to be positive and keep on it. And the world is changing, but have thick shoulders, because your professionalism is going to shine through. And if someone's nasty, your kindness is going to make them feel worse. And that's what we're trying to do right now, is stop that negativity on every level. And unfortunately, some of the new people and students have experienced that. And if you do, just don't pay attention to it. Just move past it and be the bigger person, because unfortunately, that's life too. So that's my life-changing advice for your career. But I wish you the best of luck, and I know that you're all going to make it in this career and be a shining star to what we're trying to build as a paralegal profession.
Perfect. So once again, thank you, Stephanie. Take care and all the
Thank you.
best with all the things that you're up to.
Thank you.